Okay. Um, Good afternoon, everyone. My name is Marion Thomas, and I'm with Metro Fair Housing Services. Would like to welcome you all here today to the rental eviction moratorium. Uh, Today, first of all, I would like to thank the Clayton County Library system, and especially Ms. Kimberly Oliver for allowing this most important topic to be discussed today. Also, I would like to say thank you and welcome Cole Teller to present this uh, most serious presentation that's going on now. Um, Cole is from the Atlanta Volunteer Lawyers, and he is the co-director of the Safe and Stable Home Project. Cole, we welcome you today and thank you so much for taking your valuable time out because I know you all are so busy with this particular subject going on now. So I thank you again for coming out and turn it over to you.
Wonderful. Thank you very much. And thanks for having me and giving me this opportunity to talk about Georgia's landlord-tenant laws and what tenants' rights are, especially in these COVID times. I am going to start sharing my screen. Okay. So I am going to start by just telling folks a little bit about the Atlanta Volunteer Lawyers Foundation, where I work, and the work that we do and how you can contact us for help. And then I'll get into the legal subject matter. If folks have questions along the way, you can feel free to speak up and interrupt me or put it in the chat box. I may hold questions till later if I feel like I'm going to get to that later on in the presentation, but definitely want this to be a dialogue and want to hear people's thoughts and comments and questions. So AVLF is a nonprofit legal organization. We've been around for about 42 years. And our main office is in Atlanta, but we serve all of Fulton and all of Clayton counties. And the program, I am an attorney with AVLF, and the program that I co-direct is called the Safe and Stable Homes Program, which means that we work with tenants, specifically low-income tenants who are having problems with their landlords, and we help those tenants find free legal help to resolve those problems. So some folks listening in may be familiar with Atlanta Legal Aid, and that is a different organization, but very similar in a lot of ways to AVLF. We both help tenants find free help with their legal problems. So they are another resource, and I will mention them a few times going through this today. But there is our phone number on the screen. That is our main intake line. So if you have questions about landlord-tenant issues or other legal problems you may be having, you can always give that number a call. These are some of the landlord-tenant issues that we help tenants resolve. So probably the most common issue and one that I'm going to be spending more time on in this presentation is failure to repair. Just landlords who don't make repairs to their rental property. That comes up a lot, unfortunately, but it is an area where there are laws that protect tenants. Another issue that we help out with a lot is security deposits. Landlords who just don't bother to return that deposit after the tenant moves out. So we'll talk about that some as well. Illegal lockouts, sometimes called illegal evictions, is when instead of evicting a tenant properly by going through the courts, a landlord just decides that they're going to change the locks on the tenant's property, or they might cut off all their utility service or throw all their furniture outside. All of those are highly illegal ways that landlords might try to get a tenant out. So if that happens to you, or if you're afraid it might happen to you, your landlord's threatening to do that, please do give us a call so we can step in. We also help with situations where a landlord is overcharging. Maybe you already paid your March rent and now they're telling you, oh, you didn't pay March rent, so you owe it again, or you have to pay late fees. We want to know about that too, so we can step in. And then, of course, actual evictions. When a landlord has filed an eviction in the court, we take those cases as well. Atlanta Legal Aid has a Clayton office that really specializes and has a lot of expertise in Clayton County evictions. So I put their name in parentheses here so folks know to give them a call, maybe even call them first if you've been served with an eviction in Clayton County, but AVLF is another resource and we do take those cases as well. So with that as background about AVLF's work, I want to pivot now and start talking about what tenants' rights are. And I meet tenants all the time in Atlanta and Georgia and throughout the counties who tell me, well, I know I don't have any rights because I live in Georgia, or I know I don't have tenants' rights because I live in the South. And that just totally infuriates me because it's wrong. You absolutely do have rights as tenants, but they are only meaningful if you know them and you enforce them. And so sometimes I think about tenants' rights as like a toolbox. So if you can imagine a toolbox, we might not have as big or as full of a toolbox as tenants in other states, like maybe California or New York. But we do have a toolbox, and we have, a hammer and a screwdriver and a wrench and all those key tools that you need to stand up for your rights and enforce them in the courts. So just know that you do have protections that exist. And knowledge is power. I firmly believe that if you know a little bit about what the law says, that will give you the empowerment and the strength and the ability to stand up for yourself and actually get justice. All right. So moving right into right number one, and again, I really do always start with this one because it is for sure the issue that we get the most calls about at AVLF. And in my experience is the law that landlords most often seem to break, especially when it comes to low-income tenants. It is very clear in Georgia law, it is in black and white, that tenants have the right to get repairs made. Another way to say that is that landlords have the legal duty to make repairs to their rental property. There is no ambiguity in the law when it comes to that. Unfortunately, as I said, we do get calls all the time from tenants whose landlords are not following this law. And here are just some photographs that our clients, actual clients, have shared with us to show us the conditions that they're living in. The picture on the left side of the screen shows you a sewage flood. We get a lot of calls from tenants who are dealing with that. On the right is somebody whose ceiling caved in because there was water damage on their roof and the landlord didn't do anything when the leak started, and that small leak turned into a massive ceiling cave-in. We deal with infestations of all different kinds, and I'm sorry for this gross picture that you're looking at, but I think it's important to shine a spotlight on these conditions. Tenants, many of whom have small children in the house, are living with infestations of mice, rats, cockroaches, bed bugs, you name it. And this is a landlord's responsibility to address through extermination. And then mold. Mold happens when there is moisture, a leak, a flood, that is not quickly addressed or remedied by a landlord, especially in a hot, humid climate like we have in Georgia, and we're about to be in the middle of another Georgia summer. A little bit of moisture in a humid environment will very quickly become mold. And black mold, like you see pictured on the screen now, can make people very, very ill, especially if they have asthma or COPD or other respiratory conditions. So this is very dangerous. It can also damage your personal property. So it is the landlord's obligation to fix this. And the tenant does have to do some things to trigger this landlord's obligation. So it's not automatic. The number one thing that a tenant has to do is to tell the landlord what it is that needs repair. It sounds very obvious, but I really want to emphasize this because it doesn't always happen. And the best recommendation or advice that I can give you is that you should request repairs in writing. So it's fine to call your landlord and ask them for repairs, or if you happen to see them or you go into the leasing office, you can tell them verbally, but you should also back that up with a written letter. And it doesn't have to be a fancy letter. It doesn't have to be typed or on letterhead or anything like that. A text message is written. A text message to your landlord counts as telling them in writing. The one thing that I would recommend is if you do ask for repairs in a text message, take a screenshot of that text message and save it somewhere, save it in your email or on your computer, somewhere that it won't accidentally get deleted. You could even print it out. You can ask for repairs by email. That's written as well. That is perfectly legitimate. You can pick up a pencil or a pen and write a letter by hand. The thing that I would recommend there is that you take a picture of the letter before you send it, so you don't send off your only copy and now you don't have any proof. And really what I'm telling you is the importance is making a paper trail. You want to have some record, some proof that you did request those repairs and when you requested them. Because unfortunately, what we see time and time again is tenants call our office and say, well, I've had leaks, I've had rat infestation, I've had mold, and I've told my landlord a dozen times to fix the problem and he still hasn't fixed it. And I'll say, well, how did you tell your landlord? And they say, well, I called him, or I went into the leasing office and said it face to face. And then when we talk to the landlord says, well, I had no idea. Your client, this tenant, never told me. And then as an attorney, I can't prove it. If it was all oral, if it was all, face to face or phone conversation, I can't go into a courtroom and prove to a judge that you, the tenant, actually did ask for those repairs. And without proof, frankly, it's not going to be a very strong case, and I may not be able to help you. So every communication that you have with your landlord, you should do in writing and keep that in a safe place. I actually recommend that tenants buy a folder like this. You can get this at any dollar store or CVS or Staples. It's a folder, it's durable because it's made of plastic, and it has a flap that folds over the top so it keeps things dry and safe and keeps mold and moisture off of the papers. So in this folder, you should put a copy of your lease. You should always have a written lease agreement and get a copy of that. You should keep here the receipts that you pay for your rent each month. If you pay by money order, just keep that little strip that you tear off the money order, which is your receipt, and maybe even take a picture of the money order. Any letters that you get from your landlord or send, anything from the court, keep it all organized in this place. If you don't, this is your paper trail, this is your record. And if you don't have this, your case is going to be much, much weaker. Okay, so we can come back to repair issues, but if you're, well, let me finish before I move on to retaliation. If you have requested repairs, you've done it in writing, and your landlord still has not made repairs, that is when you need to reach out for legal help. That is when you call AVLF or Atlanta Legal Aid and tell us, I've had these problems, my landlord hasn't done anything, and we can step in and at least give you some advice and maybe even write a letter to your landlord, or in extreme cases, file a lawsuit to get those repairs made or to get you out of your lease if that's what you want. So just know that our first question is going to be, what proof do you have that you've notified your landlord of this problem? So moving on to the second right I want to tell you about is tenants in Georgia have the right to be free from landlord retaliation. And if I was doing this presentation a couple of years ago, I wouldn't be able to say that because this is a relatively new law that just passed in Georgia in 2019, or took effect in the summer of 2019. Before that, landlord retaliation was not clearly illegal, but our legislature passed a law that now says landlords cannot retaliate. So what does that mean? Sometimes when something does break or needs repair, tenants can be afraid to request repair because they worry that if they do that, if they're too much of a squeaky wheel, or they bother their landlord or ask for repairs too many times, they will get retaliated against by their landlord, by the landlord filing an eviction, or maybe raising their rent, or treating them differently from other tenants. People are really fearful of this. But the law now says it's crystal clear that that is illegal. So what the law specifically says is that if you ask for repairs, if you call code enforcement, which is your right to do as a tenant, if you want the city or the county to step in and hold your landlord accountable, if you talk to a lawyer, if you call HUD, if you have a subsidized rent and you want HUD to step in and do an inspection, you are protected. If your landlord takes any adverse action against you in the next 3 months after you take that protected activity, that is illegal retaliation. Also, if you band together with your neighbors, maybe you circulate a petition with your neighbors because the conditions are bad in all of your apartments. You do a protest of your landlord, of the management company, because they're letting the conditions get so bad. You start having meetings with your neighbors. You are protected from retaliation if you do those things in solidarity with your neighbors. And sometimes people say, well, my landlord did X, but I'm not sure if that was retaliation. Just call a legal organization. You're not going to be charged to have a conversation with a lawyer, just to run it by them. There's no downside to calling legal aid or calling AVLF just to figure out if your landlord might have broken the law. So just to give you a specific example, this was a family. These were the real tenants that were living in the Brookhaven neighborhood, and their conditions in their apartment complex were very poor. Landlord was not making repairs. So this tenant got together with her neighbors, they put together a petition, and they started to stand up for themselves. And what did their landlord do but started to send eviction notices for trivial, petty little things that they had not been enforcing before that. Like if someone left a toy, a child's toy, on their back porch, suddenly they were getting citations, fines, fees, eviction notices for little minor things like that. And because of the timing, it was very clear that their landlord was doing this in retaliation for the tenants banding together and standing up for themselves. So these tenants were able to get an attorney who sued their landlord for retaliation under that brand new law, and the case did settle very favorably with a payment to this tenant. So just to give you that real life example that the law has been used, it's been tested in court, and it has been upheld. So don't be shy to stand up for your rights if you think your landlord might be retaliating against you. Okay, the third right I want to tell you about, and this one is really important. You as the tenant have the right to fight your eviction in court. And to me, this is so important because, first of all, as I mentioned at the beginning, there are landlords who try to quote unquote evict a tenant without going through the courts. And that is highly illegal. If your landlord changes your locks or just tries to force you out, literally goes in while you're not home and throws all your furniture outside, call a lawyer, call a legal organization right away, because we should be able to help you. And the other thing that I see time and time again is tenants who will get that eviction notice from a court on their door and they'll just give up before they start to fight. They will just give up and say, oh, you know what, I don't know what this means, and I'm afraid, I'm confused by this paper, and I'm overwhelmed by the eviction process, and I can't afford a lawyer. I'm just going to move. I'm just going to move. I'm not even going to fight this. And to me, to my mind, that is pretty much always the wrong decision to make, because you may have a very strong defense, or you may even have counterclaims against your landlord, because your landlord might have filed this case improperly. They might have skipped some steps or done something wrong. Or it may turn out that you have a very strong defense to the case. And you can countersue your landlord. Let's say that you didn't pay your rent. Let's say you know for a fact you didn't pay your rent. But the reason you didn't pay your rent is because the conditions in the home were so terrible, you went and stayed at a motel for a couple of weeks just to get away from the mold. We had a client who had a gas leak, terrible gas leak in his apartment, and his landlord didn't do anything about it. And he had a child, and he took his child and went and stayed in a motel for a couple of weeks so that they weren't breathing in the gas that was leaking. Well, he didn't pay his rent because he had to pay for the motel, and that was all his money. And what did his landlord do? Well, they filed an eviction, and he was able to countersue his landlord and win a nice amount of money in the courts. So again, if that gentleman had gotten his eviction notice and said, well, they're right, I didn't pay rent, I'm just gonna give up, it would have had a very sad ending for that family. So there's no downside to just calling a legal organization and saying, hey, I got this eviction paper on my door. I'm not sure what to do. Can you help me? We will tell you. If it turns out we think you don't have a very good case, believe me, we'll give you that advice. But don't you at least want to know what are your options? One caveat here, one warning, is that evictions move very quickly in Georgia. It is an accelerated, speedy process through the courts. So if you get that paper on your door and you just put it in a stack of other mail to deal with later, the next thing you know, you look up, you look up, it's 8 days later or 2 weeks later, you've missed your chance. You've lost your case already, because you only have 7 days when that eviction notice shows up on your door to file a response, which is called an answer in the court. So really that time passes very quickly. My best recommendation is that the day the paper shows up on your door, call legal aid, call AVLF for help. If you call me the day before the day before the answer is due, or even the day before your hearing happens, chances are it's too late. I'm not going to be able to help you. So don't delay, don't procrastinate on that. This, of course, is the Clayton County Courthouse. And once you file your response to your eviction, you will be given a hearing date. Now, things are a little different these days because of COVID. Hearings are not taking place in person, but so you may have an option to have an eviction hearing online via Zoom. But just so you know, you will have the right to a hearing as long as you respond to that eviction paper by filing an answer in the courthouse. Now, people, I'm sure, have questions, or at least I hope you have questions. I hope you have heard of the CDC eviction moratorium. This is really important, very timely and relevant to our current situation. We have in this country at this time an eviction moratorium, which is just another word for delay, that has been issued by the federal CDC, which is based here in Atlanta, but it affects everyone in all 50 states, including Georgia. So this right now is really the strongest and best protection against evictions that we have. A little worried about this right now because it is set to expire at the end of this month. As of today, which is March, I think 11th, Yes, today is March 11th. This is set to expire on March 31st, so just 20 days away. It may be extended. I have heard rumors that it will be extended, possibly through May. But please, if you're watching this at a later date, just understand, double check to make sure that this is still in effect if you are getting served with an eviction case after the month of March. But again, right now, as of today, it is still in effect. The other thing to tell you about the CDC moratorium is it doesn't apply to everyone. There are a lot of, you could call them loopholes or a lot of carve-outs where it may not apply to you if you are a tenant who is being evicted. Your landlord has filed an eviction. It's not a guarantee that this even applies to you. So you have to do a little bit of research to figure out if you are protected. And there's really not, this could be a whole presentation unto itself about the eviction, the CDC eviction moratorium. And I'm not going to go into a whole lot of detail, but I do just want to walk through some of the basic requirements. So here is up on the screen, some things that must be true of your situation in order for that CDC moratorium to apply to you. Number one, you have to make less than $99,000 a year if you're an individual, or $198,000 a year for families. Now, AVLF and legal aid, we only serve low-income clients, so that's generally not an issue. You must be unable to pay your rent due to loss of income. So you lost your job, hours got cut, that needs to have happened to you. You need to have applied for rent assistance, but didn't receive any. So there are different rental assistance pools that are out there. If you call United Way 211, they can tell you more about what may apply for your area, but you have to have at least tried on your own to get some financial help. Next, you need to agree to offer partial rent to your landlord. So let's say your rent is $1,000 a month. You only have $200 available. You must offer that $200 to your landlord, even if they won't take it. Even if they say, no, 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 we won't accept partial payments. The CDC requires you to at least try to make that partial payment. And then finally, it must be true that if you were evicted, you would become homeless, or you would end up in an overcrowding housing situation, meaning you would have to move in with family or friends and have multiple people packed into one home. And with that last point, you can understand why the CDC, which is, of course, a health organization, is worried about evictions. Because if you are living in close contact with a lot of other people, or you're in a homeless shelter, it is much more likely that you will get COVID and become ill. So this is a public health issue. The CDC says evictions are now a public health issue, and we really want to stop them if all of these things are true. And then there's one more thing that I see there's a couple questions popping up, and I'll get to those, but probably the most important thing I can tell you about the CDC moratorium is the tenant has to sign and submit a declaration to your landlord to be protected. So even if you are looking at these 5 checkboxes and you say, oh yeah, all of that applies to me, I'm good. No, actually you're not good until you get a copy of this CDC declaration, read it, sign it, and then give it to your landlord. And in fact, you can even file it with the court in addition to that. None of this will apply to you unless you do that. So another way to say that is the burden is on the tenant. You have to take an action to be protected. And if you Google CDC declaration, you will find there's lots of copies of this floating around online. I tried to find a good website address that I could put up here on the screen just to direct you to somewhere. And this is one that I found that I thought was pretty good. It's just www.covid19evictionforms.com. That's not my website, but it is one where you can access that form and fill it out and then print it out and sign it and give it to your landlord. So again, don't be complacent. Don't think that this protects you. You actually have to do the work to get this protection. Oh, okay. I see a couple of comments. Have I heard that the CDC declaration either has or will be extended to June 30th? Again, I have only heard rumors at this point. I was even checking the news this morning to make sure there isn't any late breaking news. My understanding is that as of this moment, it is still only good through the end of March. Again, I think that our leaders in Washington are hopefully moving towards an extension of it, but I don't want to tell you something that's not true. You know, Congress, things might go one way or another way. You never can really predict. So I hope it is extended, but as of this moment, it has not yet been. Okay, I'm going to move on from evictions now, but we can certainly come back to this. I just want to get through my presentation, and then I'm happy to come back to evictions or the CDC moratorium, and we can talk more about that because I know that's on everybody's mind. Security deposits. This is another thing that sometimes people give up on when I think they should not have given up on it. They move out, landlord says, no, 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 I'm keeping your deposit. And tenant says, it's water under the bridge. I'm not going to fight. I'm not going to fight for it. And to me, it's like, why not? That's your money. That's your money that you paid when you move in. Why wouldn't you want to get that back? And yeah, sometimes you have to fight for it to do that, but this is where a free attorney can help you. They can actually fight that fight for you. So a couple of points about security deposits. You're not entitled to get it back until after you've moved out. So sometimes tenants say, well, I can move out if I get my security deposit back. I can use that money to move. Unfortunately, your landlord doesn't need to give it back to you. They have up to 30 days after you move out to give it back to you. And the other thing to know about security deposits is your landlord can keep it if you have damaged the place that you were living beyond ordinary wear and tear. So that's the legal phrase that's right in the law, ordinary wear and tear. So what does that mean? Well, that means, you know, if you are a parent and you have 4 kids and your kids left little smudgy fingerprints on the wall, and maybe the carpet got a little dirty from all the dirty shoes that were walking on it, that's ordinary wear and tear. If it needs a touch-up paint, if it needs a good cleaning, that's ordinary wear and tear. That kind of thing should not stop you under Georgia law from getting your security deposit back. Now, on the other side of the spectrum, if you have a nice white carpet and you opened up a red bottle of wine and accidentally dumped your bottle of wine on the carpet, that's coming out of your security deposit. So, you know, that kind of thing. Or your kid set a little fire on the carpet and now there's a big burn spot. That's going to come out of your security deposit. But those are unusual examples. Usually it's just ordinary wear and tear, a little dirt, a little grime, a little smudge, and you should get your security deposit back. So, and if your landlord keeps your deposit in a way that they're not supposed to, you may be entitled to 3 times your security deposit, depending on the size of your landlord and some other factors. So if your security deposit, let's just say, was $800, and you're tempted to just say, forget it, just know that if you went to court, you might actually get $2,400. So, you know, that's money worth fighting over. So don't just give up on your deposit before you fight over it. And another tip on deposits, just do make sure you leave the home very clean, you know, put some time into vacuuming and all that kind of stuff. And the best advice I can give you is take pictures, and even better than pictures is video before you leave. You know, all your boxes are packed, they're in the U-Haul, you're good to go. The last thing you do before you close the door behind you, walk through and take your cell phone video camera and go up and down from floor to ceiling in every room. Open the cabinets, open the oven, open the fridge, lift up the toilet seat, show on the video that you kept it, or that you're leaving it in tip-top shape. Because again, the problem is some landlords will say, oh, well, you put that giant hole in the wall. And if you don't have proof to say, no, sir, I didn't, then again, a lawyer is probably not going to be able to prove that you left it clean. So always be thinking about how can you prove it. And one sort of overarching point that I really want to stress to you is remember that your relationship with your landlord is a business relationship. So, you know, sometimes people get into sort of a friendly relationship with their landlord, or maybe your landlord actually is your friend. They were your friend before they became your landlord, or even your relative. It's your cousin, it's your brother-in-law, it's your mom's best friend, whatever. Be that as it may, once you enter into a landlord-tenant relationship with the person, it's a business relationship. So think about other businesses that you interact with, whether it's a bank, an employer, maybe a credit card. It's the same kind of thing. That's why I keep emphasizing get everything in writing. I'm not saying don't be friendly. You know, I'm not saying be rude or be mean or anything like that. I'm just saying it's a business relationship. So you can shake hands, but always have your backup, always have your proof. If they tell you, well, I'm going to do X, Y, and Z, I'm going to make this repair, I'm going to give you this thing, just say, great, thank you. Can we get that in writing? Can we get that in writing? Can you just text me that and I'm going to keep that text? And if they don't say, oh, what do you mean? Get it in writing. Don't you trust me? Well, sure, I trust you, but let's just have some clear understanding. This will make sure we don't misunderstand down the road here. You know, I hope that all of the tips and advice that I'm giving you, that you never need to know any of this because you have a good landlord who lives up to their word. But doing this work for as long as I have, unfortunately, I know that it doesn't always happen that way. So just, you know, keep that voice in the back of your mind saying, how can I protect myself here? Okay, I have a question. A couple of good questions in the chat box. Okay, let me see what my next slide is. I will go back and answer those. Oh, okay. Another general tip that I really want to stress to you is to read everything carefully. And most important in that sense is your lease. I know that, you know, leases can be 20 pages long, 30 pages long. I've seen 50-page leases with all the addendums. You know, you got your parking addendum and your mold addendum and your utility addendum and whatever else it might be. Some landlords have these very lengthy leases. Read every word, read every word, read every sentence. Ideally before you sign it. But if you were pressured to sign it, you know, still go back and read it, because you won't know what your rights are or your duties are until you study and read that lease. If you are confused by your lease, maybe it's not written in a way that makes a lot of sense, ask somebody to help you. A friend, a family member, call a law organization, call AVLF or legal aid, say, is there anyone there who can help me understand what this means? Because in Georgia, the law itself, the law that's in the law books, doesn't go into a whole lot of detail. A lot of times the details are in your lease. They say the devil is in the details. Well, read that lease because you really need to know. So let me give you an example. Let's say your landlord just shows up at your door one evening while you're eating dinner and has a key, and they let themselves in and start doing an inspection. Can they do that, or did they need to give you some kind of 24-hour notice or something like that? The answer to that question is in your lease. If it says your landlord has to give you notice, they have to give you notice. But if they don't, if it's not in there, they don't. You want a dog. You or your kid want a pet dog. Can you have a dog? Read your lease. You won't know if it's in your lease. Your water bill, who pays for that? You or your landlord. Your electric bill, who pays for that? It's in the lease. These are important things. You've got to know it. So read the lease. Again, ideally before you sign it, but it's never too late. And keep written records of all communication with your landlord. We already talked about that. Okay, I'm going to go back to a couple of questions that came in. A question about the security deposit specifically. So that applies to landlords of a certain size. So if your landlord has more than 10 rental units, or if they have a separate property management company that they use, they are subject to that. They call it treble damages provision. So most apartment complexes have more than 10 units. Not all of them, obviously, but if you are at an apartment complex with 20 units or 200 units, and your landlord doesn't give you your security deposit back, you may be able to get 3 times your security deposit. Now, if you're renting a room in a, it's just a couple that's renting out a room in their home, or it's sort of mom and pop landlord and they only have one rental property, you may not be able to get that treble damages. But, rather than you trying to figure that out beforehand, I would, again, strongly recommend that you call a legal organization just to figure that out. It's a little bit more complicated than I'm making it, and I don't want to give you too much information that's not useful to you right now. But the point is, you may be able to get even more than your deposit. Another question going back to the CDC moratorium, and this is really a good question. So I said that in order to qualify for that CDC moratorium, you have to at least attempt to pay partial rent to your landlord, right? And we know, and you probably know, that a lot of landlords won't take partial rent. Your rent is $1,000, you were late, so now there's a $100 late fee. You show up with your little $50 or your little $300, whatever, and try to offer it, your landlord's gonna shut the door in your face. So how do you prove that you just tried to do that? If the question comes up down the line, did you offer partial payment to your landlord? And you say, yes, I did. How are you going to prove that? And that's exactly the right way to think about it, because like I said, it's all about what can you prove. So let's think about this. How about you brought a friend with you when you tried to make that payment? And so now you have a witness, okay? You have a witness. It's not just your word, you have someone who can back you up. You bring your sister, you bring your cousin, you bring your teenage kid, just somebody who can back you up and say that you were there. Or your landlord turns you away, says, I don't want your money, I don't want partial payment. You then text your landlord or email your landlord. Today, March 11th, at 10:30 a.m., I went to the leasing office, I offered you $300, you told me to leave because you don't take partial payments. You hit send. Now you have a record that you created at the same time or on that same day that you documented that you try to do this. You can even set your video going on your phone and walk into the leasing office with your video recording. Okay, hi landlord, I don't have the full rent, I brought you this. Oh, you won't take it, okay. Now you have a video. So any of those is okay, whatever you're comfortable with, just some sort of proof so it's not just, I offered you the money, no you didn't, yes I did, no you didn't. Now it's he said, she said, and that becomes a tough case. Okay, another good question in the chat. What can be done if a landlord breaches the agreement on entering when the lease clearly states a 24-hour notice? Yeah, this happens, and it's always just the shadiest thing with landlords showing up. Maybe you're stepping out of the shower, or got stuff going on at home, and here comes your landlord, or here comes a handyman or something. It's not an emergency. You didn't call for help. They just come in to do an inspection or something. They have some excuse. You go and read your lease because you went to this training, so you know to check that. And there it is in paragraph 10. It says landlord must give 24 hours notice to enter. Okay, so what you should do is notify your landlord that they have breached the lease. Write a letter. And again, if you're comfortable, I don't want anyone to do anything that really scares them without talking to a lawyer first. But this is one option that you have. You can write a letter. you can reference paragraph 10 of your lease or whatever paragraph it is. Dear property manager, last night at 8:30 p.m., so-and-so entered my apartment. As you will see in paragraph 10 of my lease, it says they cannot do that. In the future, please obey the lease. And depending on if it keeps happening or what happened when they came in, you may want to get out of your lease. You may want to break your lease and leave. Again, talk to a lawyer. Don't ever just move out in the middle of your lease without getting some legal advice. That should probably be another tip that I add to this training, because if you break your lease and leave, you're probably going to owe your landlord a significant amount of money for breaking your lease. Whereas if you have legal representation, we are often able to get your landlord to release you from that lease without owing that money. I'm not going to guarantee that, but that is something that we've regularly been able to do. Don't just break your lease and leave because the lease probably says you're going to owe potentially quite a lot of money to your landlord if you do that. Okay, another question. What about those who allowed families to stay at their apartment because they are homeless due to the pandemic? How should that be properly handled? Yeah, this comes up a lot, and not just in the context of COVID-19, but if you let people come stay with you or move in with you who are not on your lease, or maybe it's a visitor, you thought they were only going to be there a week and now it's 3 months later, that may be a lease violation, because chances are your lease only will allow people to stay there who are mentioned in the lease, whether they're tenants or occupants, some words to that effect. So if you really want to be on the safe side, you should notify your landlord and talk to your landlord if you have other people who are coming to stay with you. They may want to amend your lease to add those people, or they may tell you you can't do that. But better to clear it with your landlord ahead of time than to get yourself in a situation where you were, what's that cliche about no good deed goes unpunished. You don't want to get yourself into a situation where you open your home out of the goodness of your heart and then suddenly you're in violation of your lease. That is a real risk if you have any sort of rent subsidy, like a Section 8 voucher, or maybe you live in tax credit housing or project-based Section 8. You really have to follow those rules about who lives in your rental home, because those are very strictly enforced, and you could not only be evicted, but potentially lose your rental subsidy if you violated those. So, it's good to be generous, it's good to be kind and open-hearted, but just act carefully so you can make sure you're not inadvertently setting yourself up for some trouble. Lots and lots of good questions coming in. What else? Anyone have questions? Other questions?
I have a question. I didn't put mine in the chat. I
Sure.
hope you don't mind, Cole.
No mind.
Okay, my question is, what kind of enforcement is it for the people that are being evicted, even though the moratorium is in place? I have seen several situations where people actually was evicted.
Yeah, I have too. And this actually, I was just talking with one of my coworkers about this morning, that we are sort of clinging to this CDC moratorium as, for all of its flaws and loopholes, it is probably the strongest protection we have if it applies to you. But even so, even with that in place, we are still seeing some landlords moving forward with eviction and some people still getting put out. There's also a lot of confusion and gray area around what judges are doing. We know that in Fulton County, for example, they are still having eviction hearings. Even in these non-payment of rent cases that should be protected by the moratorium, they are still going forward, ruling against tenants, and then what's supposed to happen is the marshals are not actually supposed to be putting people out, that which is the very last step of an eviction. The marshals are not supposed to be removing the tenant from the home if there is that moratorium in place. But unfortunately, it seems like, some are slipping through the cracks. So it's a terrible thing when it happens, because the family or the tenant now is immediately homeless. You have been wrongfully evicted. There's not a great solution that will get you back into that home quickly. However, I would really strongly recommend that you talk to a lawyer about what happened to you, so we can evaluate your case, we can interview you, we can review the evidence and see how we can help. If your landlord may be liable, may be vulnerable to a lawsuit if they have violated that CDC moratorium. This is a very developing area of the law. So I don't have any clear or great answers for you, because the CDC moratorium was just issued for the very first time in September of this year, and there's still a lot of challenges to it in the courts, and this is all new. So the best advice that I can give you at this moment in time is, if you think it was not followed when it should have been, call AVLF, call legal aid, and we can, if not get you housing immediately, we can at least try to get you some justice and compensation down the line.
Okay, so Cole, one more question. So if I'm being proactive, if I know that maybe a tenant is getting ready to be evicted under this moratorium, do you have any suggestions? And I know they've already, received the order and everything. What can I do? Maybe, would you suggest anyone I could call to see if I could stop it?
Yes, if you suspect or you're worried that the moratorium may not be followed, maybe you're worried because your landlord is telling you, that doesn't apply to you, or that's bull, or whatever they might say. It's never too soon to act. It's never too soon to act. Again, call, I know I keep saying this, but it's really the best recommendation I can make, is to call AVLF or legal aid, and I'll give the number again. Actually, I have a slide with the number coming up, and just get some legal advice. Let us know who you are so we can get you in our system and open a case for you. And then we can be your backup, if you think this is going to happen. I mean, there's no like CDC hotline or anything like that. Like, don't call the CDC or HUD. Unfortunately, they're not taking any sort of enforcement action here, but certainly there are free legal resources out there that can help you and be ready to help you if you think this is going to be a problem.
Okay, and this is my last question. So if they are if evicted, and I heard you use the word illegally, can they get back into their place or their home?
Maybe. It would be an uphill battle. I think a lawyer would have to file a lawsuit seeking an emergency court order, which is called an injunction, to try to get the landlord to let the person back in. And that is a heavy lift. I'm not going to say it's impossible, but it would take a really strong, forceful court action and strong proof that the law was not followed. So maybe, but maybe not. But again, certainly don't let that stop you from asking for help, because I can promise you, if you don't ask for help, we're not going to be able to help you, because we won't know who you are. So just get that free legal advice and see what can be done.
Okay, thank you.
You're welcome. And there was a question or a request that I show that website again, and I don't remember it off the top of my head, so I have to scroll back here. Okay, it's COVID-19evictionforms.com. And again, this is not like the official CDC website. This is just a good one that I happen to find, where you can actually fill in the fields on the form right on your computer. and print it out. And again, another tip that I can give you is not only should you give that form to your landlord if there's an eviction pending against you and you qualify, you should file that form with the court, whether it's electronically filing it or taking it down to the courthouse and filing it in person. That's actually not required by the CDC, but it is a good idea so that you're putting the court on notice. You're saying, hey, court, hey, judge, I believe that I'm protected by the CDC moratorium. Here's a copy of the form I gave my landlord. So it's a little extra step that you can take. Because, you know, if you gave it to your landlord might say, oh, you never gave it to me. And then how do you prove that you did? So, you know, file it with the court if there's already a court case, an eviction case pending. That way, that's an extra little step that you can take to cover yourself. Okay, I think I saw another question here. Hold on. Oh no, that was it. Okay, let me show you. Okay, so here are the two numbers that I want you to have and keep with you. You can even type them into your phone. The top one is my organization where I work, AVLF, or Atlanta Volunteer Lawyers Foundation. That's our main intake number. Call us with your questions. Again, you're not sure you have a case, but you just want a lawyer to talk to or to review your case, call us. And then the lower number is Atlanta Legal Aid. That specifically goes to their Clayton office. And they have a lot of expertise with eviction matters in Clayton County and other legal issues you may be experiencing as well. So again, no charge to you for the call or for any of the services we provide. And it really, I would much rather you call and it turns out you don't have a legal case than you call me 6 months later, 6 months or a year later, and you say, oh gosh, this thing happened to me a year ago. And I say, gosh, I wish you had called me when it was happening. And that happens all the time. Every time I talk to tenants, people say, gosh, I wish I had known about you 2 years ago. I really could have used the help. But when it's too late, it's too late. We are about at our 2 o'clock time. Any other questions before I wrap up?
Okay, Cole, so we don't see any questions coming through on YouTube.
Okay.
But I would like to take the time to thank both you and Miss Marion for bringing this information to us. This is vital information that we are receiving. For our participants, those of you who may want to review this webinar or you may want to share it, it will be posted on the Clayton County Library System YouTube page, so you can always go there and review everything that Cole and Miss Marion had to share with us today. Okay, and thank you very much for joining us. And again, thank you for your presentation.
Thank you all. And I'll just leave you with my knowledge is power slide because a little bit of information can go a long way.
Okay, thank you.
Thank you, Cole.